I'm a big believer in second chances, even for people who commit serious crimes. Who deserves a second chance? Who gets one? And who decides? I'm Jessica Henry, and I'll be your host of Just Justice. I'm a former public defender, a professor of justice studies, and an award-winning author. And I'm excited for us to find new ways to put justice back into our criminal legal system. Hey everyone, it's Jessica Henry from Just Justice. And since we recorded this episode, President Joe Biden went on to pardon 8,064 people, making him the most pardoning president ever in history. And of course, then when President Trump took office, he did his own little pardoning thing. And without further ado, let's begin our episode with Professor Rachel Barkow. Hello, and welcome to Just Justice. My name is Jessica Henry, and I'll be your host. Today we have the pleasure of talking with Rachel Barkow. Rachel is the Charles Seligman Professor of Law at NYU School of Law. She's also serves as the faculty director of the Zimmerman Center on the Administration of Criminal Law. From 2013 to 2019, she served as a member of the U.S. Sentencing Commission. She's also the author of the groundbreaking book, Prisoner of Politics, Breaking the Cycle of Mass Incarceration. Professor Barkow has written more than 30 law review articles and is recognized as one of the country's leading experts on criminal law and policy. Rachel is a graduate of Northwestern University and Harvard Law School and served as a law clerk for Judge Lawrence Silverman on the U.S. Court of Appeals for the District of Columbia and for Justice Antonin Scalia on the U.S. Supreme Court. Rachel Barkow, welcome to the show.
Thanks for having me.
So I wanted to have you on Just Justice because you are one of the nation's leading experts on clemency. And clemency is one of the last available opportunities for someone to get a second chance, someone who's been incarcerated to get a second chance. And so I'm really excited to have this conversation with you. And I thought we could just start with a basic question, which is, what is clemency and how does it relate to second chances?
So clemency is the ability of either a governor or the president to give somebody relief from their conviction. And it can take different forms. It can be a pardon, which would be absolute relief. It's deemed to be complete forgiveness from your conviction. So it gets rid of all the consequences of having a criminal conviction in the form of a pardon. It could be a commutation, which would be a sentence reduction. So you would still have collateral consequences that might follow from your conviction, but you get a reduction in your sentence length. It could be a remission of fines, for example, and it could be a reprieve. So for people who are on death row, they could get a temporary stay where they are no longer facing execution. So it has different forms. The most common ones, though, would be commutations and pardons.
So you said there's the governor's power to issue these pardons and commutations, but there's also the president's power. And I know that a lot of your work has focused around that federal grant of clemency, that federal use of clemency. And I'm wondering, at the federal level, where does the president get the right to issue a pardon or to commute someone's sentence?
The pardon power at the federal level is from the Constitution. It's actually right next to the power that the president has to be commander in chief. So it was a big deal to the framers that this power be included in the Constitution. And it gives the power to the president to pardon people. And that includes pardons, commutations, reprieves, remissions of fines. And there's very few limits that can be put on it because it's a constitutional power. So it's quite broad and sweeping.
And at the state level, most of the governors who have the same power, does that come from their state constitutions? Or are there laws that give the governors power to pardon?
So it makes a lot of it as state constitutional provisions. Some of them have the ability for it to be modified legislatively, though. So at the state level, you see a lot of variation where the president has sole and absolute power to decide whether or not to give somebody clemency. At the state level, there have been different formats adopted. So some states have boards or commissions that the governor has to consult with. In some cases, it's up to a board or commission to decide. States have various ways of dealing. Sometimes it's in a board that's responsible for both pardons and parole. So it's basically a mix of institutional designs at the state level. Most of them, though, emanate from their state constitutions, but there are some where it's been established by statute what the power is and what it looks like. And when that has more flexibility like that, obviously it allows for different kinds of institutional adjustments to be made, whereas those kinds of things could never happen at the federal level without a constitutional amendment.
Let's go back to that in a little bit. I just want to keep talking about this. It's an interesting thing, right? Because prosecutors bring charges against a person who's been accused of a crime. And if they go to trial, which doesn't happen often, or a jury convicts them, or even if they don't go to trial and they plead guilty and they're sentenced, the system has kind of done its thing. And then there's an appeals process. And so the idea that an executive can come in and undo a conviction that's already gone through that process is a really significant power. And you wrote back in 2015 in the University of Chicago Law Review article that you authored, you wrote, "The use of the pardon power is a necessary element in a fully functioning system of criminal law." And to me, that was a really strong statement. I'm just wondering why you view the clemency power as necessary and what you view its function as. Why do we have this clemency power? Why did our founding fathers think it was so important?
They recognize that we would not be infallible when sentences are imposed, and that there needs to be a way to correct injustices, that there needs to be a way to check prosecutors who go too far, and to recognize people who demonstrate rehabilitation and reformation, and to have an opportunity for there to be forgiveness and error correction in the system. It does stem from the power of a king as a matter of grace to give people relief from conviction. So its roots go back to a model that maybe is more religious in nature and has a connotation to it that's around grace and forgiveness. But by the time the framers put it in the Constitution, I think they had a conception of it that went beyond that and did include thinking of it as a way for the chief executive, for the president, to exercise authority over the executive branch, to make sure that the executive branch didn't go too far in bringing prosecutions, to use the clemency power in some cases to bring tranquility to the country. So if you had a rebellion, you had a moment of national uprising that just required the president to take a step of clemency and forgiveness and turning the page on something so that the country could heal. They saw all those roles to be served by clemency. And I think today, if we want to update some of that a little bit, I think we can recognize that after jurisdictions take a hard line against other second look mechanisms, the more we get rid of things like functioning parole or furloughs or compassionate release options, really any other second chance mechanism, or to have no other avenue for people to clear their records because there's no expungement process or what have you. As those things contract, clemency takes on even greater importance because it then becomes the only game in town in some jurisdictions. So, for example, at the federal level, once parole is abolished, you really have no other way to get a second look at a federal sentence that someone is serving for most of the time since parole was abolished. You couldn't get compassionate release. You had no mechanism to go and get released by a judge. And even now, it's still fairly narrow, which means that if you wanted to correct an excessively long sentence, the only place you can go is to the president and to ask for a commutation. So its importance has only grown over time, I would argue, in our governing structure, but certainly there were reasons right from the founding that suggested it would be important.
So just to sort of summarize what you said, because I do think this is so important. Clemency serves a whole bunch of different functions. And if I'm hearing you correctly, one is this idea of mercy and showing mercy, showing grace. But more fundamentally, it's making sure punishments fit the crime. So if someone was sentenced to a super long term of imprisonment, it's a way to correct that when we have a different perspective on something. Do you have any examples of that? Maybe a person or a case who really deserved clemency because of a long sentence?
I'll give you a categorical example. So if you think of the height of the 1990s and the panic over crack sentencing, there's a race to just make them ever harsher by Democrats and Republicans alike. And we get to a point where crack sentences are just astronomically and crazy severe. So you can get a mandatory minimum just for possessing crack, and you get life sentences for dealing relatively small quantities of crack cocaine, even for first time offenders. So the crack sentencing regime, we all recognized as time went on that that was bonkers, but Congress could not muster the political will and energy to fix it. So you had attempts and they could never make any retroactive changes. So you have tens of thousands of people who had been serving long sentences for crack cocaine that had since been changed for people going forward. Congress got enough political energy to say, like, we shouldn't do that anymore, but they didn't make the fix retroactive when they did it. It took them 20 years to fix it at all. And when they fixed it, they didn't make it retroactive. So we were living in a society, this is during President Obama's time in office, we're living in a society that has recognized those sentences were too long and they had been changed with bipartisan support. But there wasn't enough political energy to make the change retroactive. And that meant that for people serving those sentences, there's no parole, there's no other way to get relief from them. The only place they could turn would be to the president of the United States. And so one of the things that Barack Obama did as president was give clemency to an awful lot of people who had been serving excessively long sentences for crack cocaine, because that was the only avenue they had. And he mainly focused on people who had been serving life sentences for crack, because we can talk about this later if you want. There's not a great institutional structure for granting clemency at the federal level. So even though I think he wanted to do more, it was hard to get the system up and running at high levels of grants. But he did a decent amount. He had over 1,000 people that got clemency, and the bulk of those were for crack sentences. And I think that's a good illustration of using clemency as a means of error correction for sentences that we all recognize today are disproportionately harsh.
Right. And not only that, but it's also a great example of the symbolism that clemency can bring. When a society's priorities change, or when a lawmaker's priorities change, allowing a president to grant clemency, it's a way to send a message that we no longer support these kind of super long sentences for instance, nonviolent drug offenses. And you also spoke about how clemency has become so important because, as you mentioned, at the federal level, there is no parole. A lot of people don't realize that. And it's not just at the federal level. A lot of states have also abolished parole. And so folks are stuck in prison sometimes forever because there's no mechanism for them to come out, regardless of what they've done in prison, regardless of how much they've changed or transformed. And all of these super long sentences dovetail with the mandatory minimum sentences that people are serving, where judges have no discretion in terms of what they impose. And as you mentioned, there's so much damage that comes from a conviction, so many collateral consequences. People can't get housing and jobs. They're barred from all kinds of things because of these convictions. And pardons can erase all of that. So there is this really important modern function that we can trace back to the King of England and even before that are really important. But you just also said that clemency is this potentially really powerful thing. And Barack Obama, for instance, took a look and said, oh my goodness, there's all these folks serving crazy long sentences. Let's fix that. But you also said that the system, at least at the federal level, is very convoluted. And I think that's being generous, right? It's perhaps ineffective. It's certainly not the most productive. Can you walk us through how clemency actually works in practice? Because I don't think anyone knows. It's just sort of like the president comes out on Christmas Eve, and says, hey, I'm going to commute all these sentences, or I'm going to pardon all these people. But how does that happen?
All right, so there is an official process for granting clemency, and the president does not have to follow this, which I think is important to flag because you do have examples. For example, during his first term in office, President Trump did not follow this procedure. He had a more ad hoc clemency granting approach. But the process that is in place that most presidents do follow most of the time, it's a kind of ridiculously layered process that I don't think anyone in their right mind would design if they gave it a moment's thought. So the process, first of all, is run by the Department of Justice. And that's noteworthy because the Department of Justice is the agency of government that brought the criminal charges in the first place. So the very same prosecutors who made the decision to prosecute somebody's case and seek the sentence that they did, that same agency is in charge of the clemency process. And it's a unit of the Department of Justice called the Office of the Pardon Attorney. But the Office of the Pardon Attorney, one of the first steps they take before they decide what to do with a clemency petition that arrives on their desk is to ask the prosecuting attorney's office, what do you think about this petition? And there's great deference given to the prosecutors who brought the case. So right off the bat, we have a huge design flaw, which is that you really should not have the same people who prosecuted a case making an assessment about what should happen to it. Everything we know about cognitive biases suggests they're the wrong people to make those decisions. But that is how it is currently set up in the federal system. So there's a lawyer in the Office of the Pardon Attorney's office who would be the first line person to receive this petition. And it's a petition that people can file. You can go online. There are forms at the Office of the Pardon Attorney's website, and you fill out and you answer a bunch of questions about why you deserve a commutation or why you deserve a pardon. If you're seeking a pardon, there are certain requirements, like you have been 5 years post-release from your sentence, a little bit longer if it's a serious crime, and that you have a clean record in that period. And you fill out your application and you explain if you're currently incarcerated, what your release plan would be if you were given a reduction, et cetera. So you file that petition, it goes to this lawyer in the Office of the Pardon Attorney. And then if they think this makes sense, like, hey, this might be a grant, then it would go to the pardon attorney herself. It's currently Liz Oyer. So she would review it. And then if she thinks this is a good idea, it would now go to its third layer of review, which would be a lawyer in the Office of the Deputy Attorney General. So it's now left a place where the whole focus is pardons and commutations, and it has entered an office in the Department of Justice that is responsible for a huge amount of supervising and oversight of a lot of things that typically take precedent over clemency application review. So the Office of the Deputy Attorney General is responsible for supervising every criminal case in the country, right? That's like the last line for all criminal case supervision, and would be dealing with any number of other urgent national security kinds of issues. But somehow they have to also find time to review these clemency petitions. So you can imagine right off the bat, we're going to have some backlog issues because getting that space on an agenda is going to be difficult. And now you have this question of the office that's now reviewing it is the same office that supervises all the U.S. attorney's offices. So this is very much a prosecutor's office. These are people who think like prosecutors. They were prosecutors. They are prosecutors. They supervise prosecutors. And they're now reviewing the clemency petition. And traditionally, we've had some issues with it being hard to get out of that office with a positive grant recommendation. I think things have been better in the Biden administration, but institutionally, that's a real question. So if the lawyer who looks at it in the, what we'll call, it's the DAG is what it's known as for short, in the DAG's office thinks it looks good, then it has to go to the Deputy Attorney General. So the Deputy Attorney General now has to make time to review this clemency application. So, if we thought the office as a whole was busy, few people rival the obligations of the Deputy Attorney General. But they now need to carve out space to look at this petition. And if they think it merits a positive grant, they would then send it on to the White House. Now, if they don't think it does, it'll just die there. At any one of these points, if someone says, no, this doesn't seem meritorious, it doesn't go any further. And I should add, by the way, that this process is entirely done on pieces of paper. So this is not like computer and speedy. There were like folders that would be transferred from office to office. I don't know if they have since fixed that, but when I last checked, it was still a paper process. So the Deputy Attorney General reviews that application. If they think it merits a positive grant, it goes over to the White House. And in the White House, it goes to the White House counsel's office. Again, we're now at a space where they're doing a lot of things other than clemency. If there's a Supreme Court nomination, they're like full steam ahead on Supreme Court nominations. They're doing other judicial nominations. They're doing any other litigation around the president and the president's authority. And they need to squeeze into their schedules reviewing this clemency petition from this everyday regular person who has filed it. So it gets backlogged there as well. And it's being reviewed by someone who probably didn't take the job because they wanted to work on clemency. Usually people want to go to the White House counsel's office because they want to work on the Supreme Court nominations, and they want to work on big national security and presidential powers questions. And they're typically not people who are really excited to do clemency. And they think about this from the president's perspective, which is a grant that you were to give that for whatever reason, if that person were to commit another crime or be in the news in some negative way, that's going to reflect really badly on the president. So the person in the White House counsel's office reviewing this is absolutely thinking about the politics, and they're deciding whether or not to say yes to this petition. If they think yes, then it would go to the White House counsel. I have been told in the Biden administration that somehow those 6 layers of review are not enough. And they also have it reviewed by the Domestic Policy Council. So there's an additional reviewing layer. And only if every single one of those people think it should be a grant, it then goes to the president. And then it's up to the president to look at it and decide to give it a positive recommendation. So it should surprise nobody listening that that process for most people takes years, like literally years, for a petition to go from being submitted to, if it is going to be a positive grant, making it all the way to the end. And that's one reason why we've had a backlog at the federal level of thousands of petitions for many, many years now. It's an inefficient process with duplication that's not necessary, with review by people who aren't really trained or focused on criminal justice related issues. It's bonkers, I guess, is how I would summarize it. And now it's more than 7. Like, it's even crazier. The way they fixed it was to add another layer, which is just nuts.
Rachel, you have been a little bit critical about prosecutors being in charge of clemency reviews. You wrote this in a 2021 op-ed piece, and sort of like the fox guarding the chickens analogy. And, one of the interesting things is if you look at some of the sentencing reforms that are going on at the state level, it's putting prosecutors, at least in some jurisdictions, at the center of things. Prosecutor-initiated resentencing laws, for instance. One argument that I've heard is that prosecutors have a duty to do justice that goes well beyond just seeking convictions and getting sentences. And I understand your skepticism. I'm a former public defender, and when I hear about these things, I kind of think you've got to be kidding me. And yet they have been successful within certain jurisdictions. And I'm just wondering, can you say a little bit more about your concerns or how you react to the idea that prosecutors could play an important role in this resentencing process and in these clemency petitions?
I wouldn't exclude them if they want to go to court and ask for there to be relief granted. I applaud that. I think that's great. I just would never give them the exclusive control over that. And if it's a choice between which actors do you want to have take a second look at someone's sentence, they'd be my last pick. I do believe they aim to do justice. I think that most prosecutors, their heart is in the right place. But what you're asking someone to do in a second look determination is figure out if they made a mistake the first time, right? And you're asking the prosecutor to look at their own work. And that's a really uncomfortable position to put somebody in. It's just, as a matter of human nature, people have a really hard time dealing with the fact that if they asked for an excessive sentence or they overcharged somebody and that person then had to serve that time in prisons, which are not great places, right? Prison conditions are pretty bad everywhere, that they were responsible for that. And they did that. And admitting and owning up to that is uncomfortable for people. And there's a cognitive dissonance associated with it that, frankly, creates incentives for people to want to say, no, I didn't make a mistake. This person does deserve to be there. I didn't put somebody in prison unnecessarily. I didn't make them do that. They did that. They did that to themselves. They deserve that sentence. And that temptation to find that it was justified is going to be pretty strong. And it's going to be strong not only when you're evaluating your own decisions, but if you're being asked to evaluate the decisions of your colleagues, people you work with every day. It's really uncomfortable for someone to say, my colleague, the person I share an office with, the person I go to lunch with, they screwed up. They put you in prison for too long, and I'm here to say it should be corrected. That's a really uncomfortable position to have to go back to the office now and work with that person. And for the district attorney to be in charge of an office and come out and say people in their office screwed up is also really uncomfortable, because now people in the office are going to think that the district attorney is not a team player. They're not defending the office. They don't respect what people do. So it's really just as a matter of office culture and individual human psychology. asking a lot of people to reevaluate their own decisions. It's why we have an independent judiciary, right? It's why we think about neutral decision makers, and prosecutors aren't neutral. And I guess I would say, as my best evidence for why it worries me, is what we've seen with wrongful convictions, because we have cases where DNA evidence has definitively established that somebody is innocent. Like, it's definitive. The DNA does not match. And when you go back to the original prosecutors in the case, they say, well, I don't believe it. I don't believe it. That person is guilty. I don't believe that they're innocent. And they will fight it when people say, but there's science, like it's actual science. So we know, and not to mention the cases where we have other evidence and witnesses recant, and those people are also innocent. But even in the cases where it's definitively established with science, prosecutors resist it because it's really, I think, a matter of human psychology uncomfortable for someone to have to live with the fact that their mistake imprisoned another human being, either at all in the case of wrongful convictions or for too long when it's an excessive sentence. So I would not put prosecutors in charge of second looks. If you want to add it as an additional thing that they could do, great. But I think no one should put that in place as the lone mechanism for reevaluating sentences.
You know what's interesting to me? I know you've been fairly critical of the Biden administration's use of the clemency process to date. You testified before Congress in 2022 about this issue. You recently wrote a New York Times op-ed piece, which I would recommend to everyone to take a look at because it's so well written and interesting. And he's only got a short time left in office. So I'm wondering, can you tell us about what the Biden administration has done in the area of clemency and sort of how many applications are still pending, how many pardons he's actually issued? And you can, in this conversation, by the way, include, if you'd like, the mass commutations or pardons that he issued in the marijuana cases, which I know officially don't count as pardons in the DOJ statistics, but I think are very interesting anyway.
Yeah, so I would say that at least as of today, and we're speaking the day after the election. So as of today, President Biden's record on clemency, I would give him a D if I were grading him. So he's barely passing by the skin of his teeth, really. And the reason I would give such a low mark is because he came in with a large backlog of petitions. And there are still over 9,000 petitions pending. And most of the petitions that have been resolved, either they timed out, meaning the person just got released before they even had a chance to get their petition ruled on, or they were denied. So he denied over 7,900 petitions that have been filed. And he's only granted 25 pardons and 132 commutations. So his grant rate is 0.1%, which is the lowest grant rate of any president we've had in a term. Now, I should say this, there's a big caveat there because I suspect and hope that there'll be a flurry of grants now that the election is behind us. And he has between now and when he leaves office to give those grants. And my hope would be that someone will be calling attention to the fact that these are numbers that are shameful. They're shameful for his legacy. They're shameful for anyone to leave office with this kind of a record. He, I am sure, would point to what you had alluded to before, which is he had symbolic proclamations during his time in office. One was that he pardoned people with simple marijuana possession convictions. So the first thing you need to know about that is when he gave his proclamation for these pardons for simple marijuana possession, there wasn't anyone in federal prison who was released as a result of that. Nobody, not a single person. And federal possession marijuana convictions are not a big part of what the federal system has. There's a lot of people who are charged with distributing marijuana, but not a lot of people who are charged with possession. And most of those cases would have been cases, so, it could be on federal lands, like a federal park. And most of them are actually District of Columbia cases. So people that got simple possession charges in the District of Columbia. So when he announced that he was pardoning those people would then have to fill out a form with the Office of the Pardon Attorney to get the official certificate of pardon and show that they met the qualifications and that it actually applied to them. So it's not a very large number of people who actually have filled out the form to get it. It's 246 people so far out of a total applicant pool that should qualify. If we got everybody, would be over 7,000. So it's small ball anyway, but more importantly, it doesn't affect anybody currently incarcerated. So when he did it, I think he was thinking this was a symbolic gesture that would make governors around the country think about how they think about simple possession of marijuana, where that's more of a thing. At the state level, possession offenses would be a bigger deal than at the federal level. But, even that, I have to say, I'm not super impressed by it because most of the convictions are for sales, not possession. And the fact that he couldn't even bring himself to issue any kind of relief for the distribution of marijuana when it's legal in a huge chunk of the states now. So, these are people who'd been convicted of something that is now legal in lots of states, still not legal at the federal level. But we've clearly changed our tune on marijuana sales. I live in New York. You can see marijuana dispensaries all over the place. The idea that someone's serving a prison sentence for that currently today, they're inside of a locked cell for something that people can sell openly and make money off of. I think that's offensive. And I think a better symbolic gesture on his part would have been that, to say, look, we think differently about marijuana distribution. But there too, it was very small, didn't affect anybody currently incarcerated. And then of the people that he did give commutations to, this very small 132 number of people who got a lower sentence as a result of his actions, most of those people had already been released from prison also. They were released during COVID. They were people who were released under emergency legislation that was passed after COVID called the CARES Act. And Bill Barr, as Attorney General, had authorized their release to home confinement so that they weren't in a prison environment where the odds of getting COVID were higher. And so they've been out anyway. They still were subject to going back, but they had shown that they were out and living law-abiding lives. And so giving them a commutation wasn't exactly the stuff of bravery. And it was, again, really small because he could have categorically done that for everybody serving a CARES reprieve. And he didn't even do that. He kind of picked and chose among the people and only gave it to this small subset. So this clemency record is really quite poor. And he would need a really amazing, it's not even the fourth quarter, right? This year would be the fourth quarter. So this would be like the last 2 minutes of the game. He really needs in this last month or so that he has left in office to get things done. He really needs to make this a focus. And I really hope he does. I really think this would be a nice way to send a real message on some of these issues. And he can now do it without any political repercussions. He is not going to be running for office again. We are not going to see his vice president taking over that office. And there are some really deserving cases, thousands of them, that I hope he turns his attention to.
One area I think you and I both agree on is Donald Trump, when he was last in office, went on an execution spree. He revived the federal death penalty where it had been long dormant, and he executed a whole bunch of people. It would be amazing if President Biden were to commute all the death sentences of the people on federal death row. It would be a wonderfully symbolic message. It would prevent people from dying at the hands of the government, because clearly some of the folks who are on federal death row will face execution under the new Trump administration.
Yeah, and I'll just add to that, if I can, just quickly. President Biden did promise to work on ending the federal death penalty as one of his campaign promises. And, that would require legislation. So I understand that's a tough lift because you have to go to Congress and you have to get legislation passed. But this is something entirely within his control and could certainly be a meaningful step to show that he was serious when he said he was really committed to that.
Yeah, for sure. And I want to keep talking about some of the former presidents. You had mentioned President Obama and that he had this sort of vision. I think you said he'd like to get more done, but he gave about 1,000 pardons, particularly to people serving long, nonviolent drug offenses. What do you rate him? How would you rate Obama if you gave Biden a D? How are we rating Obama?
Well, if he's on a curve, he's going to get an A, because compared to modern presidents, on a curve, he would be the best of the bunch. But without the curve, I think you give him a B, because he set it up too late, for starters. He didn't focus on it until his second term. And I get it. There's politics involved with these. But even there, he waited fairly long into the second term to get things going. So we were worried about time running out. And then there wasn't a well thought out process put in place for the scale that he had envisioned for clemency. And so it really was a victim of bad institutional design to be able to get grants. And he had a set of criteria that he said were the people he wanted to give grants to. And evaluations of what he did shows that he missed thousands of people using his own criteria. So it's definitely, I commend him for what he did. I do think he's the best example of a modern president doing something, but that could have been much better. And it's not like he wasn't warned, which I know because I was one of the people pushing this.
You were one of the canaries in the coal mine saying, let's get going.
Yes. Early on, as part of the campaign and campaign memos, after he's elected, putting this on people's agenda, I was one of many, Nikichi Taifa and Mark also. There's a whole group of people, and it just sat there with nothing done. And so I do think more could have been done, but I do appreciate what was. And certainly as compared to his modern peer presidents, it was better.
Yeah, and that brings us to President Donald Trump. And so obviously Donald Trump inherited a whole bunch of these applications that had been filed before him. And we got a bunch of new applications in. And yet President Trump's very first pardon grant was to Sheriff Arapio in Arizona. I don't even know if I said his last name right. But can you tell us about how Donald Trump in his first term in office looked at clemency, what he did or didn't do, and how he used the clemency power?
Yeah, so that process I described of going through all those layers of review, that was not for him. There was really no review. It seemed to be that if you had his ear because you were a political crony or a friend or you knew somebody who was one of those things, then you bypassed all of that and you just got clemency as basically a Trump loyalist. So Sheriff Arpaio was signal number one. He supported his campaign, even though his crime was actually contempt of a federal court order for violating constitutional rights of people in his district. That's grant number one. He went on to give a grant to somebody who had committed war crimes, as found guilty by a military tribunal. He gave pardons to all kinds of political associates, people who had worked with him on his campaign, who were charged with illegal activity as part of his campaign, and big donors. A lot of people who were big donors got it. So his was basically a who do you know? Can you bypass the system? The numbers were still quite low. Like his percentage was very low overall. He didn't do much. And of the people who did get it didn't look like the federal prison population. I can tell you that. This is overwhelmingly white people, wealthy people, a lot of financial crimes. Because there was no vetting, you have some people who received a pardon from him who have since their pardon have been convicted of some pretty serious domestic violence. Charges have been leveled against some of the people who got grants from him. There's been a series of articles on that. So his process was ad hoc and I would say biased in favor of people that knew him, which is not really what you want a clemency process to look like. He did have a few grants that came through. Again, it was kind of who you knew, but he had a grant early on to this woman, Alice Marie Johnson, really a wonderful woman who had received a ridiculously long drug sentence. And her case had been championed by all kinds of criminal justice reform types and caught the attention of Kim Kardashian. And Kim Kardashian brought that case to the attention of President Trump, and he gave Alice Marie Johnson a clemency grant. And she was very grateful, and she's a lovely human being. And I think he liked Alice when he met her. And so there were also some grants basically through Alice. If she knew of other people, I think she put in a good word for some of those. So if you look at his list, you'll see a few what I think of as politically unconnected people by traditional measures. But I think they got in because either they knew Alice or they knew some of the other criminal justice reformers who had been working with the Trump administration. And so there were a couple regular people, we'll call them, who weren't high-flying donors or political cronies, just people that got stuck with long sentences. He had a handful of those. But for the most part, his clemency record, I couldn't even give it a D. I think you have to give it an F because I think you can't have a grant process that's so ad hoc that's literally just based on whether you kiss his ring and you make a campaign donation. He definitely took the historical roots of the king giving dispensation to its fullest portrayal in modern times, because I think he really viewed it that way. Like, he is the king of this pardon authority. He will dispense it to the people in his kingdom that he thinks should get it and not really be bothered by a DOJ process. We'll see what he does in a second administration. I will say he did recognize that the Department of Justice process was broken, like going through that is kind of ridiculous because it takes so long. But you do want some mechanism in place to make sure that it's a process grounded in equal treatment of people and not just about favoritism.
About that, because the truth is there are no limitations. So there might be a preference in a democracy to make sure that the pardons and commutations are being distributed fairly, and not just because someone has access to the president or access to Kim Kardashian, who has access to the president. And yet he didn't do anything wrong, right? I mean, like, the pardon process allows him to do what he did.
Yeah, he didn't do anything illegal, as far as we know. Obviously, it would be illegal to take a bribe to give a pardon, and there's no evidence of that we have. And so there are limits, I should say. It's not like it's completely unbounded. You can't sell pardons, but there's no evidence of that. And so he didn't do anything legally wrong, but I think it's fair game to judge pardons politically, as a populist, to say, hey, what do I think of these pardons as a political matter? I mean, I guess you could argue he was just reelected, so they weren't bothersome enough to people. I suspect we'll be seeing a lot of pardons in the next administration of other people who have been charged with crimes related to him and his first time in office.
Like the January 6th people.
I was just about to say
Yeah.
the January 6th attack on the Capitol. He has said he wants to give pardons to some of those people. He hasn't said he was going to give it to all of them. So that'll be interesting to watch if he was going to do blanket clemency or if he's going to look to see who engaged in violence, who was there and trespassed on the Capitol, but there's no evidence that they themselves engaged in violent behaviors. I don't know, but he has definitely indicated that he wants to give clemency to at least some of those people.
The Supreme Court seems to have issued a decision that appears to insulate the president, any president, from actions they take in office related to their official duties. And that's pretty broadly defined in that Supreme Court decision. The obvious concern, I think, is that the president power by a sitting president can sort of act with impunity. And now he or she, but he can authorize his cronies to do whatever he wants. Go and do my bidding. And if you go and do what I tell you to, you'll be protected because I'll just pardon you. Is there anything to stop that?
Not really, because we can't even get evidence of these conversations after the immunity decision that the court issued. They said all the conversations that he has as part of his core executive functions, which absolutely includes the pardon power, conversations that he has about that, you can't even introduce that as evidence. You can't use it. And the justices, when they issued the opinion in the immunity case, there was some disagreement among them about how would this play out, for example, in a case where there was a bribe for a pardon. And Justice Barrett was one of the conservative justices who dissented on that basis, who she had thought that the other conservative justices had gone too far in ruling out the kind of conversations and information that might be related to that as evidence to be used in cases. But she was in the dissent on that. So bringing one of those cases is all but impossible. I don't know how you would do it. And so I don't know what to say. I feel like you have to hope that the people in these positions respect the rule of law and that they will be ethical and not do things just because they can't be prosecuted for it. I think most people in life behave with a moral compass that isn't about will I or won't I be prosecuted. However, we know there is a track record of people in his administration who flout the law, and they have been charged and convicted of things and shown that they abuse their positions of authority. And so we'll have to see what happens, but there's all kinds of reasons to be super worried about it.
Yeah. So then what about the other options? What other options do we have? Is there a way to reform the clemency process that would be constitutional? Are there legislative alternatives that we should be pushing hard for in lieu of clemency and pardons, especially if the access to them is going to be somewhat limited, at least for this particular Trump administration? What do you think?
So I tested